When is a statement not considered hearsay evidence? Imagine you're in a courtroom and someone says something outside of court. You might wonder if that statement can be used against someone. That's where hearsay rules come into play. Hearsay is an out-of-court statement offered to prove what it says is true. But not all statements are automatically hearsay. A statement is not hearsay if it is used for a reason other than proving the truth of what was said. For example, if a witness says they heard someone shouting, the statement might be used to show the effect on the listener or to show the speaker's state of mind. It's not about proving who was right or wrong, but about showing how the statement impacted others. There are also specific exceptions where hearsay can be admitted because courts find them reliable enough. One example is when a party involved in the case makes a statement against their own interest. If someone confesses to a crime, that's usually allowed because it's seen as trustworthy. Another exception is when a statement describes or explains an event right after it happened. This is called a present sense impression. For instance, if someone says, "I see a fire," while the fire is happening, that statement can be used because it's made close in time to the event. Excited utterances are also not hearsay. These are statements made during or right after a shocking or startling event. The idea is that people under stress are less likely to lie or fabricate. For example, if someone shouts, "There's a car accident," right after it occurs, that statement can be used. Statements about someone's mental or physical condition at a certain time are also not hearsay. If a person says, "I am feeling very anxious," that can be relevant to the case. Medical statements like describing symptoms or medical history are accepted because they're practical and often truthful. There are other exceptions, like business records, which include documents kept regularly in a business, and dying declarations made by someone who believes they are about to die. These are accepted because they're considered reliable sources of information. Understanding when a statement is not hearsay is important for defending your rights. If the prosecution tries to use out-of-court statements that don't fit these rules, your lawyer can challenge their admissibility. They want to make sure only trustworthy, relevant evidence is considered. So, to sum it up, a statement isn't hearsay if it's not used to prove what it says is true, if it falls under an exception, if everyone agrees to its use, or if the court decides it's fair to admit. This helps protect your rights and keeps the trial fair.